Hello friends, a very warm welcome to UnSarkari. I am Vikas Bhardwaj. Now, today also we are taking up a very important contemporary and a dynamic topic which is going to help you in your understanding in writing general studies paper 2 answers and even if case study appears indirectly in the ethics paper apart from political science and international relations and also certain aspects during your interview. The question is Article 356 of the Indian Constitution. What it actually means. Is it for restoring law and order or is it a political tool? Now, in general parlance, we see this whenever this comes into news and current affairs. But what we are trying to do, we are trying to complete its understanding with respect to the imposition by the center, that is what is called president's rule in states, and the kind of debate it is having. Because it is a very, very vital safeguard for the constitutional order. On the other hand, people say it has become a kind of a political weapon. So more than 130 times it has been invoked since independence, and there are several high-profile, you can say, controversies also. On document, it is empowering the President of India to impose president's rule when there is failure of constitutional machinery. But what we are trying to understand, is it a necessary remedy for breakdowns in governance or it has become a tool for political manipulation? This is what the question you will also be getting. So it is a very important, very important role, and you can say very important act and very important article when we speak about this provision's role in India's federalism. So the recent cases, for example, the Arunachal Pradesh case of 2016, Uttarakhand 2016, Maharashtra 2019, and even the recent case of Manipur. Now, Article 356. Let's look at its placement. Article 356, part of Emergency Provisions, Part 18 of the Constitution. It is allowing the President to assume state functions if governance cannot proceed in accordance with the provisions of the Constitution. That means if the state government is unable to function constitutionally, acting on a governor's report or other information. This is the broad language, especially the failure of the constitutional machinery. So the president is going to act on governor's report or otherwise, as I just said. So the parliamentary approval is required within 2 months. Extensions are possible up to 3 years. Now there are related provisions, for example, Article 355, Union's duty to protect states, and Article 357 also. And the Parliament's legislative power is there during President's rule. So what is that? We can say that this has led to both flexibility and controversy. But what is true, what you're going to write in your answers, that parliamentary oversight is built in, but the central's role remain dominant. Now, if we see the roots of Article 356, they lies in the colonial era emergency powers because it is inspired by Section 93 of the Government of India Act 1935, which allowed British governors to take over provincial administration. But its inclusion in the constitution was contentious because there was a debate and there was division among members. Dr. Ambedkar defended the provision as a last resort. Last resort, okay, please mind it. It would be a dead letter, not using very occasionally but very sparingly. There were critics like H.V. Kamath and K.T. Shah, sir. They warned of potential abuse and central overreach. So what Dr. Ambedkar said, if at all they are brought into operation, I hope the president will take proper precautions before actually suspending the administration of the provinces. Proper, proper precautions. So that is why this provision came part of the constitution reluctantly, and expectation was there that it will be used in a rare manner. But what happened? What happened? Because Article 356, as I just said, was intended as a constitutional remedy for extraordinary situations. It is a constitutional remedy for extraordinary situations. But is it actually happening? Let's see the pattern of frequent and sometimes partisan use. That is how the constitutional intent and political misuse one has to see. It was actually a safeguard against genuine breakdown of constitutional governance to preserve national unity and constitutional order. But it is the language, the broad language, which helped successive central governments to dismiss state administrations, often under contested circumstances. So, what comes to our mind? That duality is there. What is the duality? Duality is constitutional safeguard versus political weapon. This is the duality, and that is at the heart of controversy. Why? Because more than 130 times it has been used, dismissal of opposition-led state governments, especially during periods of central dominance. There have been allegations of political engineering undermining state autonomy. So, what we have to understand, where it is necessity and where is the abuse. That is why let's see a record. Let's see empirical record which you can quote in your answer. That initially from 1950 to 60 it was used sparingly. Why? Because political independence, instability, and regional demands were reflecting that. So the central dominance actually is going to change the scenario. 1970s and 1980s is showing the mass dismissal. You can see 17, 30, then 20. You see, mass dismissal of opposition governments. Frequency declined since 1990s. We can see so, and there are you know high profile controversial applications also. That means there are tensions underlying it. So what you have to write in your answer when you are tracing that there was Congress dominance and after that political fragmentation and emergency era, then 1980s is reflecting regional party growth, there were frequent dismissals, and coalition era, decline of Congress dominance is there. But then since 2000 in the last 25 years, frequency is reduced, but there are recent controversies. So it was the SR Bombay case, very important, a watershed judgment which fundamentally reshaped the legal landscape of Article 356. That is what you can write. Fundamentally reshaped the legal landscape of Article 356 because Supreme Court asserted that the president's satisfaction is not beyond judicial scrutiny. Not beyond. That is why president rule is subject to judicial review. And the true test of a government's majority lies on the assembly floor because the majority of the government must be tested on the floor of the assembly and not by governor's subjective opinion. Now what judgment did? Judgment is imposing crucial safeguards like dissolution of assembly before parliamentary approval is unconstitutional. So it's a safeguard. It is curbing arbitrary dismissals and reinforcing federal principles. That is what you have to write in your answer. Curbing arbitrary dismissals and reinforcing federal principles. What we can end by saying it is a cornerstone of Indian constitutional law because Article 356 is only used as a last resort, must be used only as a last resort. So judgment is aligning with the recommendation of Sarkaria Commission. So it was the ideas, the Bombay judgment that is, articulating the set of doctrines, what we can say. That is why we are saying the key doctrines from SI Bombay judgment. So, so it is a guide to use in case of Article 356. The judicial review is very important because it is giving right and power to the courts to examine whether president's rule proclamation was based on relevant material and not modified. Floor test. The only legitimate way to determine majority is a floor test. Parliamentary approval cannot dissolve before parliament approves the proclamation. Secularism. Action subverting secularism can justify president's rule as secularism is the basic feature of the constitution. And warning and the last resort. First warning must be there, exhausting all other alternatives, then only it must be invoked. That means it is not a tool of political convenience, but remedy of last resort. Now, Sarkaria and Panchi Commission recommendations, when we say they are also taking, steps towards extensive review of state-center relations. I am using the word extensive. You have also write in your answer so that to bring the feel and the emergency provisions. Their recommendations are shaping both judicial and political approaches. Why? Sarkaria Commission is saying that Article 3 should be used only in extreme cases. Government report must be a speaking document with objective and verifiable ground. Prior warning must be there. It is essential except in emergencies and should not be dissolved before Parliament's approval. So it is stressing restraint, transparency, procedural safeguard, and Panchi Commission is even talking about localized intervention, localized emergencies instead of statewide presidential. If in a district, if in an area there is a problem, please solve that first. And recommended amendments to Article 355 and 356 to prevent misuse. So it's a modern approach to federalism, impartial governors, fixed tenures. These are the ideas which were discussed. Now, why governor's role is so important? Because governor's role in Article 356 process is both pivotal and controversial. You have to write that. It is important also, it is necessary also, it is mandatory also, but it is controversial also. Because office is supposed to be constitutionally neutral. It is a very important constitutional actor. He is or she is a neutral constitutional head, but most of the time seen as agent of the center. Discretion is limited, must act on the advice of Council of Ministers except in specific situations. For example, Supreme Court in Nabam Rabia case 2016, it went on to say governor's power are subject to judicial review, cannot act arbitrarily. So that is why judicial interventions have sought to clarify, sought to put rail guards, sought to limit the scope of governor discretion, but the debate is still there because there is lack of objectivity and undermining of state autonomy is there. Anti-defection law, floor test and legislative majority is another very important thing because political defections is the key word here. Political defections and shifting legislative majorities. Shifting legislative majorities is triggering invocation of Article 356. So anti-defection law was designed to address these things, but its implementation has also been fraught with controversies, delays and also jugaad. Supreme Court has always emphasized that the floor of the assembly and not the speaker or governor is the proper forum for testing majority support. It is the floor of the assembly, not the speaker or governor. But it is not happening all the times because speaker decide on disqualifications, but their decisions are subject to judicial review. Floor tests are only the one constitutionally valid method. And recent cases, as I just told you, of Arunachal Pradesh and even Uttarakhand, we have to see, they are highlighting the interplay between defection, speaker's power, and president's rule. These words must come in your answers. So, delay or manipulation in disqualification proceedings can precipitate constitutional crisis. This is what has happened. Delay and manipulations. That is what every party wants. So let's take the case study of Arunachal Pradesh crisis 2016 because it showcases complex interplay of constitutional provisions. One is constitutional provision, another what we can say political maneuvering, and third is judicial intervention. Three things are there: judicial intervention, political maneuvering, and constitutional provisions. So crisis was there. 21 Congress MLAs rebelled against the Chief Minister. Governor advanced the assembly session and set the removal of Speaker as the agenda without, without advice of the Council of Ministers. Speakers disqualified those rebel MLAs. Assembly met in community hall, removed the Speaker. President rule was imposed. Later Supreme Court quashed the governor's action and restored the government. You see? So Supreme Court decision to restore the dismissed government underscored the primacy of constitutional process, primacy of the rule of law, primacy of the constitutional structure, and also it went on to highlight the dangers of executive overreach. So what is this example is? This example is the example of importance of judicial review. Importance of judicial review in safeguarding federalism. Similarly, let's see the Uttarakhand case study. Imposition of president rule before floor test was to be conducted. It was also said unconstitutional. What happened? Political turmoil was there. 9 Congress MLAs rebelled, leading to loss of majority for the chief minister. Appropriation bill was controversially passed by voice vote. Opposition demanded there must be a division. Now governor recommended floor test, but president rule was imposed before it could occur. High Court again quashed the proclamation and it restored the government and ordered the floor test. Supreme Court upheld the need for floor test. What it is doing? It is reinforcing Bombay principles. So that means judiciary's insistence on floor test is only the legitimate means of determining majority support, reinforcing the safeguards established by Bombay case. So two things what we are finding here, there is a tension going on between constitutional process and political expediency. tension between constitutional process and tension between greed for power. That is what we can understand. Similarly, case study of Maharashtra. Again, what it is important to understand here, this is an example of procedural complexities. Complexities of formation of government when there is hung assembly. What happened? Post-election deadlock was there. No party or alliance could form government after the assembly elections. Governor invited parties in order of strength, but none could demonstrate majority support. President rule was imposed after 15 days of unsuccessful attempts. Later on, coalition of Shiv Sena, NCP and Congress, it went on to stake claim and form the government. President rule was revoked. Now, this episode also raised question about governor's discretion, timelines, and the role of president rule in government formation. So, this is a complexity of government formation is reflected here. This highlighted delicate balance must be there between constitutional norm and what is political reality. This case also highlights the debate about governor's role and also the safeguard against misuse of Article 356. Now, what are the recent trends? What we can say 21st century contentious circumstances because the decline is there in the frequency since 1990s, but high profile controversies are there. Rise of coalition politics and regional parties have reduced the incentives for arbitrary dismissals. It has reduced the incentives because a regional party may be supporting the party at power in center, or it may be having its own individual existence. You can understand. Think about West Bengal, think about Kerala, think about Andhra Pradesh in the past, think about state like Odisha, think about Bihar, think about Jharkhand and so forth. So post 2014 concerns about renewed centralization and partisan use is reflecting the idea of majority government having a very strong base. For example, the Manipur crisis. President rule was imposed amid ethnic violence and administrative breakdown. It was again sparking debate over thresholds, like when it must be done, how it must be done. So the call is for reform and stricter safeguards. That means intervention must be there, but how and why? Because it reflects that our political landscape, even in the second and third decade of the 21st century, remains very vibrant. So the political misuse and the partisan patterns, as we have just said, this pattern, as I just said, the empirical studies we have just seen through that chart, the pattern is evident our different parties and different eras. Congress 1950 to 19, Janata Party 1977, BJP post 2014. In Sarkari Commission says in 52 out of 75 cases article was misused. That means political engineering, especially where the states having fragile coalition or hung assemblies. The judicial and commission interventions, you can say they are actually reducing, you know, reducing the kind of situation which is happening, but it is not the complete elimination and misuse of the provisions. So there is a pattern we can see. So you have to understand and bring into your answer and in your notes the keywords and also what kind of features are there. So if we compare with the rest of the world, so this is a contrast because what India requires is vigilance and reform. Vigilance bhi chahiye, reforms bhi chahiye. In Canada, Emergencies Act requires federal provision consultation and is limited in scope. United States, no explicit constitutional provision for state emergencies. Intervention are rare and based on statutory authority. Germany, emergency powers are tightly regulated. Strong judicial oversight. Emphasis on proportionality. Article 356 is broad and clear in India but open to central overreach without adequate guardrails. So Indian model is more susceptible to political misuse. Now, reform proposals and constitutional amendments which you will be writing in your answer and ending it. Sarkari Commission, last resort. Detailed and objective governor report, avoid dissolving assemblies before parliamentary approval. Panchi Commission, localized emergency interventions, limited duration to 3 months with strict review, strengthening the independence and tenure of governors. And also some demand is there to precisely decide and define what is the failure of constitutional machinery. Enhance judicial review and transparency and involve election commission also in certifying the need for extending president's rule. So these are the range of reforms which the question must be asking you the way forward because there is a persistent risk of misuse. So the ground must be clarified. Strengthening of procedural safeguard must be there. Independence must be there of the key constitutional actors. It must be the real weapon and not political weapon. But academic and media critiques are there. Legal scholar, media outlets, Indian Express, Hindu Week, you can quote anything. They highlight the risk of political misuse. They highlight that there must be more clear guidelines, stronger judicial review, respect for federal principles. You can see, and you have been made notes, and you've been writing on your own also. Public debate and scrutiny is there. So Article 356 is necessary, but it must be tightly regulated. There must be more accountability so that federal structure is preserved and it is more robust and systematic. Again, in genuine crisis, it is very important because it gives power to center to restore order and constitutional governance during genuine breakdowns. It prevents prolonged administrative paralysis and lawlessness, very important, and it facilitates fresh elections and the restoration of democratic government. So judicial and parliamentary safeguards, they have reduced the arbitrary use. That is what we can conclude. And it is essential for national unity in a diverse and a complex federation like India. The challenge is to ensure that this power is exercised judiciously and sparingly. That is what even an district magistrate is supposed to do. What are the critical perspectives we see? The provision's broad language and politicization of governor office. That is what two things we can see. It has eroded public trust. So that is why there must be not any misuse. There must be not no undermining of state autonomy. Elected governments must not be disempowered, and democratic processes must not be suspended without any reason. So politicization is the key thing. Neutrality must be there, and deletion and radical amendment is not the solution. It is actually reform which is required rather than abolition. Supreme Court judgments in the post-Bombay jurisprudence, if we see, then you can always quote about Rameshwar Prasad versus Union of India, dissolution of Bihar Assembly before its first meeting was held unconstitutional. Similarly, governor's report must be based on verified and relevant material. You can quote that. Floor test is the only valid method. Harish Chandra Rawat, as I just told you about Uttarakhand case, that was the floor test was ordered there, and governor's action must be within constitutional limit. So that means judicial role and rule of law and judicial review. So courts have expanded the scope of judicial review, and it has reinforced political, or you can say procedural safeguards. So the way forward is that a robust framework is required. Procedural requirements, detailed, objective, and public governance report. There must be, transparency. Prohibit dissolution of assemblies before parliamentary approval. Limit the duration and scope of interventions. Localize measures wherever possible. Enhance the independence and neutrality of governors. So, what is the ultimate goal? Balance between the need for effective crisis management and preservation of India's federal and democratic character, which is reflected through timely elections and restoration of democratic governance. So, this is what we can say in conclusion, that it is vital. Yes, it is vital. It is contentious. It is a very important feature of Indian constitutionalism. Judicial and commission interventions have curbed but not eliminated the misuse. The challenge is to ensure that the provision is used only in the genuine cases. Vigilant judiciary, public scrutiny, they are very important to preserve federalism and democracy. Therefore, the debate continues Article 356 as a constitutional safeguard or a political tool. So the evolution of judicial doctrine, commission recommendations, public debate, they all point towards more reform, more enhanced role of judiciary in a positive way, and also Indian federalism fulfilling its duty towards the masses. So this is what we can say with respect to breakdown of constitutional machinery or article 356. That is what we have been talking, and I believe that this is going to help you how to frame your answer more correctly, how to bring key vocabularies, and also how to make notes, and also further reading whenever you are reading newspapers or current affairs, so that you get clear cut objective understanding, thereby scoring very good marks in your examination, whether it is MCQs in the prelims or whether it is the mains examination. Approach, methodology, consistency, and correct ideas are the key. That is what we at UnSarkari are strive to do. Wishing you all success in your examination. Do join our courses and programs for success.